A win today for the White House in efforts to restrict mail-in voting. The U.S. Supreme Court saying implementation of the president's executive order can move forward. Mr. Trump called on his administration to create lists of eligible voters and ordered the U.S. Postal Service to deliver mail ballots only to people on those lists. 23 states, including California, sued to block the order, arguing that states and Congress have the power to run elections and that the changes could lead to chaos and abuse. Most election experts believe any changes, if they're allowed, will not happen in time to affect the November election. Ballots also at the center of a California State Supreme Court case today. Riverside County Sheriff Chad Bianco being sued for seizing more than 650,000 ballots earlier this year. Bianco says he took the ballots to conduct his own recount after claims of questionable votes in the Prop 50 special election. CBS LA's Gio Insignares is live now to tell us about today's arguments and why both sides feel confident, Gio.
Yeah, a lot of details in this one, Riverside. So let's start breaking it down for you. The California Supreme Court paused the investigation back in April and agreed to hear these cases, ordering Bianco's office to return the ballots to the registrar. Those ballots have still not been returned, and the question here is whether Bianco should have even taken them in the first place.
This is about corruption in California.
That was Riverside County Sheriff Chad Bianco before Monday's hearing, arguing that the legality of seizing about 650,000 ballots is not about election integrity or any political motivation.
This is about whether or not a corrupt attorney general can stop a lawful investigation.
Earlier this year, Bianco, who was a Republican candidate for governor, seized the ballots from the Prop 50 special election. According to officials, the alleged discrepancy came from a flawed pilot program, a handwritten vote tally the registrar's office later scrapped for undercounting. In the courtroom today, Bianco sat with his attorney as petitioners argued he ignored a process the legislature already wrote into law.
There is a whole host of statutes called the Elections Code, thousands of them, that the legislature has laid out what you do when you're involving ballots or election materials. And what the sheriff did here just ran roughshod over those provisions.
Gubernatorial candidate and former California AG Javier Becerra, who's also listed as counsel on one of the cases, called Bianco's seizure an assault on elections and voters' rights.
Right now, while we still have chance before the November 3rd election, let's make it really clear to everybody, including law enforcement, what you can and cannot do with that precious vote that we want everyone to cast.
Petitioners say state law already spells out how to challenge an election, a recount, or a formal contest in court, and that Bianco skipped all of it. Bianco, though, sees it differently. He says he had a legal duty to investigate once he got a complaint, and that the ballots are evidence he's safeguarding for the courts.
We're hoping that we get a good ruling. The arguments are in our favor. The case law is in our favor. We just have to hope that the California Supreme Court justices see it that way.
But justices seemed skeptical of that during today's arguments, questioning how a search warrant could override election law that says ballots should never leave official custody.
Attorneys representing the petitioners also said they were very satisfied with how the hearing went today. Meanwhile, the ballots remain in an undisclosed location, still out of the registrar's hands. The court is expected to rule within 90 days. Riverside.
Gio, thank you.